When a single individual steps into a massive corporate structure, there is an immediate, inherent asymmetry of power. Management holds the capital, sets the schedule, and dictates the environment. The worker offers only their time and labor. Left entirely to market forces, this structural imbalance naturally drives the institution to extract maximum output from human capital at the lowest possible cost. To prevent that natural slide into exploitation, the state engineers a counterweight. We call this mechanism labor law. Course BHL6313 examines exactly how this intervention works in Malaysia. It outlines the specific statutory framework designed to enforce the mutual rights and responsibilities of both employers and employees. Passing this course requires moving past the rote memorization of isolated rules. You have to understand how these statutes interact as a unified system. The syllabus is specifically structured to help you build a cohesive mental model of these legal dependencies, moving from broad international directives down to precise local enforcement. We can visualize Malaysian labor law through this model. It operates as a layered architecture, carefully designed to regulate every aspect of the working relationship. At the very bottom, we have international macro policy. These are the universal directives that dictate baseline human rights across the globe. The middle layers take those broad international concepts and translate them into strict, non-negotiable minimum standards for the domestic workforce. Mastering this material means mapping this exact protective architecture. You are studying the structural safeguards built to prevent systemic exploitation before it occurs. The origin point for worker protection actually sits outside of Malaysia. It begins with the International Labour Organization. The ILO operates at the macro level. They research global working conditions, establishing baseline international provisions to protect workers across all member states. Human resource departments must understand these international baselines because they act as the raw filter for the domestic legislation that governs daily operations. The primary function of the EA 1955 is stipulating absolute minimum labor standards required by law. It establishes the hard floor for fundamental metrics, dictates exactly what companies must pay, how many hours they can demand, and strict protocols to terminate agreements. But this introduces a critical threshold question. Who actually qualifies for the protections housed inside this pillar? The law bifurcates all workers into two distinct paths. This single classification dictates all subsequent legal liability for a corporation. The first path, a contract of service, legally defines a person as an employee. It grants full access to the Act's entire protective ecosystem. The second path, a contract for service, defines a person as an independent contractor. It structurally isolates them, cutting off standard statutory benefits. HR departments spend vast amounts of administrative energy managing this specific binary choice. Misclassifying a full-time employee as a contractor in an attempt to save money is a primary trigger for severe administrative rulings and prolonged legal disputes. A single error at this foundational level structurally invalidates all subsequent corporate compliance. The entire legal defense collapses. Once a worker is legally secured under a contract of service, the protective architecture expands automatically. The baseline wage and hour protections of the 1955 Act are instantly augmented by compulsory state-mandated safety nets. The first ring provides physical security. This is governed by the Employees' Social Security Act, or SOCSO, of 1969. SOCSO functions to mitigate the catastrophic fallout of workplace accidents. If an employee is injured on the job, legislation guarantees access to specific recovery benefits. The liability coverage even extends to slow-moving damage, compensating workers who contract occupational diseases over years of service to a company. Because medical costs and workplace risks evolve, SOCSO undergoes frequent statutory amendments. HR must continuously monitor these changes to ensure they remain in compliance with benefit payouts. The second ring provides long-term financial security. This is driven by the Employees' Provident Fund Act of 1951. The EPF mandate uses forced contributions from both the employer and the employee to mathematically guarantee a measure of post-retirement financial stability. The exact calculus of these contributions is rigid, but subject to legislative updates. Historical amendments, like those enacted in 1997, actively altered the financial burden placed on employers. By legally binding these twin safety nets to the central employment contract, The state successfully shifts the financial burden of long-term human capital maintenance directly onto the employer. The central pillar and those financial safety nets apply universally across the workforce. But modern corporate environments are not monolithic. Specific demographic traits within a company trigger highly specialized regulatory overlays. For example, the Employment Restriction Act of 1968 dictates the exact rigid terms under which non-Malaysian workers can be legally integrated into the local economy. Age introduces another strict overlay. To prevent brutal historical conditions that once plagued industrial labor, the state enforces the Children and Young Persons Act 1966. Management faces severe legal consequences for violating strict prohibitions on employing underage persons in commercial operations. Beyond demographic identity, the law scrutinizes physical location. Where a person works demands specific environmental compliance. High-risk environments trigger the Factories and Machinery Act of 1967. This mandates rigorous, unannounced safety inspections by the Ministry of Human Resources. Simultaneously, the Local Government Act 1976 grants state authorities the power to impose direct punishments on corporate officers for safety breaches, a provision that overrides standard Employment Act protections. Finally, the workforce is required to evolve. This is governed by the Human Resources Development Act 1992, amended in 1996. This act forces the creation of councils, heavily populated by employer representatives, to actively fund and drive the continuous upskilling of the labor pool. These demographic and environmental overlays actively transform a static two-page employment contract into a complex, dynamically regulated liability matrix. Looking at this completed model reveals the true scope of Malaysian labor law. A single worker's daily routine is simultaneously governed by all of these intersecting, interdependent layers. This exact architecture is what identifies and guarantees basic employee rights. Without the specific mechanisms of this matrix, those rights exist only in theory. Because the system is unified, a breach in a specialized outer ring, like failing a machinery inspection, immediately compounds legal liabilities back down at the foundational contract level. This is why memorizing the statutes is only the first step of your education. To master this course, you must analyze these principles of law by examining specific cases and administrative rulings. Real-world legal practice forces you to apply these rigid, fixed legislative rules to fluid, unpredictable disputes between management and staff. True human resource compliance relies on understanding this statutory architecture well enough to actively defend both the stability of the institution and the dignity of the individual worker.